Welcome to Company and Partnership Law class. Today we look at Section 1 of Unit 6. Unit 6 deals with liquidation. Under Section 1 of Unit 6, we look at what liquidation is, winding up is, and dissolution. Session objectives. By the end of this session, you should be able to define liquidation, differentiate among liquidation, winding up, and dissolution. You should be able to explain the winding up process and describe the process of commencing winding up against a company. What is liquidation? Liquidation consists or includes both winding up and dissolution. Thus, winding up plus dissolution gives you liquidation. Therefore, you have to define what a winding up is. Winding up simply means that the process whereby a functional corporate body is made to cease to be a functional corporate body. In other words, the process whereby steps are taken to ensure that a functional corporate body or a going concern company ceases to be a going concern. Now, the process involved in winding up include appointment of liquidator. The liquidator will sell the asset, take possession of the assets of the company, sell them, pay liabilities after gathering all the resources and it has been sold. Now, dissolution simple means the official pronouncement of the name of the company from the register of members and its publication is what you call dissolution. So when winding up starts and the company's name is fully struck out from the register of companies, then we say liquidation has taken place. So as I said, summation of these two gives you the liquidation. Remember, both solvent and insolvent companies can undergo liquidation. Insolvent company means companies that are not able to pay their debt when they fall due, or a company whose liability exceed its asset. That's insolvent company. An insolvent company, they are liquidated under Act 1015, whilst solvent companies is being liquidated under Companies Act 2019, Act 992. A solvent company is a company which can pay its debt when it falls due, or its asset is higher than its liabilities. Now let's proceed with the. Now you should know that we have two types of liquidation. We have the official liquidation and private liquidation. The official liquidation basically deals with situation whereby a company is not able to pay its liability and the company is forced to wind up. But with private liquidation, the company is solvent yet it wants to wind up. We will discuss those ones in the subsequent sessions. Now, winding up, what is the effect of commencement of official liquidation. The Corporate Insolvency and Restructuring Act 2020 Act 1015 gives the effect of commencement of official liquidation. That's when winding up starts. What are the 8 effects, or what are the things that will follow? Now, section 89 of Act 1015. Act 1015 simply means in the full text, Corporate Insolvency and Restructuring Act 2020 Act 1015, but for short, Act 1015. Period of commencement. So winding up commences when a resolution is passed or winding up order is made by the court. When winding up, so section 90 says that this with cessation of functions of the directors. The Act provides that when winding up commences, the powers of directors are vested in the liquidator. So once winding up commences, the director has no role to play. All the powers of the director will now be vested with the liquidator, and the liquidator will be in a fiduciary position towards the company. The only power that will be left with the directors is the fact that they will be allowed to prepare the annual financial statement with the permission of the liquidator. Now, section 91 of Act 1015 also deals with cessation of business of a company. The Act provides that when winding up commences, all the business of the company will cease except business that is beneficial to the winding up of the company. It simply means that once winding up commences, the company will not carry on any business. The only business that the company is allowed to carry is those businesses that will enhance or that will lead to the winding up processes. Section 92 of Act 1015 also deals with custody of property of the company. Once the winding up commences, the liquidator will take possession of the assets of the company. Section 93 of Act 1015 deals with prohibition of civil proceedings. The Act simply provides that once the winding up commences, no action or civil proceedings will be brought against the company except proceedings by secured creditors in realization of their amount, except with leave of the court. It means that if winding up commences, the only group that can bring civil action against the company is those with secure creditors. However, if you want to do so, if you don't fall within that angle or that category of people, then you have to seek the leave of the court. You also have the transfer of shares on commencement of winding up. This simply means that when winding up commences, any transfer of shares after the winding up is void unless the transfer is to the registrar or with the approval of the court. Now, commencing winding up against a company. The Act provides the following. On the commencement of winding up proceedings against a company, civil proceedings against the company shall stay, and any transfer of shares of the company within that period shall be void. This is what I just indicated in the earlier slide. The court may, on application made by a party to the petition or registrar, stay proceedings. So when they make application, the court will stay a proceeding by or against the company, or regarding the property of the company during the interval between the presentation of the petition for an official winding up and the commencement of winding up. So this can be found at section 87 of Act 1015. Previously, this was under section 6 of Act 180, but this act is no more. Act 180 has been repealed by Act 1015, but the provision is still the same. Now, Chabe J said, where a company passes special resolution, remember special resolution is 3/4 of those who are entitled to vote, for an official winding up of the company, the directors cease automatically to perform any of their functions as directors. They can only do so if the liquidator sanctions a continuance. It means that they can, once the liquidation starts or once they pass the special resolution for liquidation or for wind up to start, the directors will not have any function to perform. However, they can only perform certain functions upon the permission. Sanction here simply means that permission, upon the permission of the court for them to do so. The learned judge continued, from that moment the company is in liquidation. I therefore hold that a special resolution for the winding up of a company is not a proceeding against the company within the meaning of section 6 of Act 180, which is the same as section 187 of Act 1015 as we indicated. Now, in the case of Pioneer Construction Products Limited v. Fandor, the court held that reading section 6 of Act 180, which is now at section 87 of Act 1015 as a whole, the expression proceedings against the company as used in the section meant proceeding taken by an entity other than the company itself. So it means that when the company itself passed special resolution to wind up, that one could not be considered as a proceeding against the company. It will only be proceeding against the company if it is initiated by a third party. So a special resolution for the winding up of a company therefore was not a proceeding against the company, and the provision of section 6 could not be called into aid, or could not be called in aid. So you know the correct section for that is section 87. We quoted this provision because at the time the judgment was made, that section was in effect. However, upon passage of Act 1015, that provision could be seen from section 87. So the provision is still relevant. In the Pioneer Construction Products Limited v. Fandor, the court held that under section 17 of Act 180, which is now section 93 of Act 1015, said no action or civil action except an action by a secured creditor should have been proceeded with or commenced since the directors had passed the special resolution winding up the company. With the passing of the winding up resolution, section 17 became applicable, whether or not the court had full knowledge about the fact and the action should have been stayed. So it means that under section 93 of Act 1032, once a special resolution has been passed for the winding up, whether the court is aware or not, when it brings to its notice, the court must stay proceedings. By way of summary, in this session, we have learned that liquidation is the process of having a company to cease its operation. We also realize that liquidation, winding up, and dissolution are often regarded as synonymous. Thank you and have a nice day.